This morning, March 9th, 2026, the Chief Justice of the United States Supreme Court, John Roberts, read aloud the most momentous trade verdict in American history, and with 6 words, he stripped the President of the United States of the economic weapon he had used to scare friends, destabilize global markets, and bully Canada into submission for over a year. The court concluded 6-3 that the International Emergency Economic Powers Act does not authorize the President to apply tariffs. Full stop. No appeals, no workaround through the same law. Done. What happened next is where this narrative turns exceptional, because within hours of that verdict arriving, Canadian Prime Minister Mark Carney's administration secretly disclosed that the legal exposure for the United States Treasury now sits at $175 billion. That is not a projection. That is not a protest sign number. That is the sum computed by the Penn-Wharton budget model, one of the most respected neutral economic institutions in the United States, indicating the total value of IEEPA tariff collections that are now legally exposed to return. This is no longer a commercial issue. This is a legal calamity for the White House and a structural windfall for every nation that was harmed by these tariffs. And what makes this moment unlike anything in post-war American trade history is that the Supreme Court, including 2 justices selected personally by Donald Trump, decided to undermine the legal superstructure he spent 2 years establishing. In this breakdown, I'm going to walk you through exactly what the Supreme Court ruled, which tariffs it abolished, and which tariffs survived, because that distinction counts significantly. I'm going to tell what happened inside the White House in the hours immediately after the verdict dropped and why sources described the response as full-blown panic. I'm going to show you how Trump sought to replace the dead tariffs inside the same business day using a different legislation and why legal scholars are already calling that approach constitutionally unstable. I'm going to explain what this means for Canada specifically, the $175 billion number, Carney's official declaration, and what Dominic LeBlanc stated in Washington days ago that implies Ottawa is now negotiating from a position of legal dominance. And so Andy McGee give you 3 options for how this restructures North American trade before the CUSMA review date of July 1st, 2026. Subscribe to join the community. Leave a comment so we can keep the debate going and share this video if it offered you value. Let me walk you through the ruling itself, because every word Chief Justice Roberts picked was purposeful and terrible. The case challenged Trump's use of the International Emergency Economic Powers Act, the legal authority the White House cited to levy tariffs on Canada, Mexico, China, and eventually the entire world under what the administration called a reciprocal trade emergency. IEEPA allows the president authority to control foreign commerce during a national emergency. The Trump administration contended that the word regulate was broad enough to cover charging imports. The tariffs are simply one weapon of commercial regulation. The Supreme Court said no. Roberts wrote in the majority opinion that the 2 terms regulate and importation cannot bear such weight. 6 justices concurred, 3 dissented. The court instantly invalidated the IEEPA duties on Canada, Mexico, and China, placed under what the White House called the fentanyl emergency measures and the tariffs on all countries imposed under the reciprocal trade order. According to sources tracking the ruling's language, the decision was crafted so precisely that any attempt to reimpose tariffs using IEEPA would fail at the district court level before reaching the appeals process. The door is not only closed, Roberts welded it shut. Point 1, the fentanyl tariffs are dead. Trump has imposed 25% tariffs on Canada and Mexico, citing border security and fentanyl trafficking as the national emergency grounds. Canada had repeatedly argued that the classification was arbitrary. Canadian fentanyl seizures are a fraction of 1% of total U.S. seizures, the overwhelming majority of which arrive across the southern border. The court agreed tacitly by concluding that IEEPA simply cannot justify tariff authority regardless of the emergency frame. The emergency didn't matter. The law doesn't allow it. Point 2, the reciprocal tariffs are dead. The White House had implemented a tiered framework of so-called reciprocal tariffs on trading partners across the globe, with Canada facing additional levels of economic pressure. All of that gone. Courts will now process individual claims, and firms will begin filing for refunds against $165 billion in collected duties, the Penn-Wharton figure for total IEEPA tariff money collected to FAR. Point 3, the Section 232 tariffs survived. This is the important subtlety that every other site is concealing in paragraph 11. The tariffs that have done the most harm to Canada, the 25% tariff on Canadian steel, the 10% tariff on aluminum, the 25% tariff on Canadian vehicles, and the levies targeting Canadian softwood lumber were not implemented under IEEPA. They were imposed under Section 232 of the Trade Expansion Act of 1962, a separate and older legislation that allows the President authority to restrict imports that harm national security. The Supreme Court did not address Section 232. Those tariffs are still in effect. Canadian steel and aluminum exporters that shifted $35 billion in merchandise to the United States in 2024 are still paying. Canadian auto manufacturers are still hurting. Point 4. Trump's same-day replacement. Within hours following the verdict, the White House announced a new global import penalty of 10% imposed under Section 122 of the Trade Act of 1974, a separate legislation, a different legal theory, effective within 5 days for 150 days. The Section 122 fee came with one notable carve-out. Commodities originating under CUSMA, the Canada-US-Mexico Agreement, are excluded. That exemption is not generosity, it is strategic. It keeps Canada locked inside CUSMA instead of walking away from it before the July review. Point 5, 24 states quickly sued. On the same day the Section 122 tax was announced, 24 state attorneys general filed a federal lawsuit contending that Section 122 requires a true balance of payments crisis as a precondition for its implementation and that no such crisis existed. Legal analysts offer this challenge substantial prospects of success. If it succeeds, Trump's alternative tariff regime crumbles along with its predecessor. Subscribe right now, because what I'm about to show you is what happened inside Ottawa, inside the White House, and inside the emergency trade meetings in Washington on March 6th, and why the numbers Canada is now carrying into those negotiations are unlike anything any trading partner has ever brought to a table with the United States. According to diplomatic sources, the Canadian government had wargamed this very scenario. Carney's trade team had been watching the Supreme Court issue for months. An internal legal analysis had determined that a positive verdict was more plausible than public markets were pricing. When the ruling dropped at 10:02 a.m. on February 20th, the response in Ottawa was not celebration. It was disciplined activation of a legal and diplomatic plan that had been pre-built. Dominic LeBlanc, Canada's Minister of Trade, made a comment within 90 minutes after the verdict. He said the ruling underscores Canada's argument that the IEEPA tariffs imposed by the United States are unreasonable. That statement was not emotional. It was legal positioning because LeBlanc and his team knew that every dollar collected under IEEPA from Canadian exporters is now legally recoverable, and the quantity is enormous. Conservative leader Pierre Poilievre termed it a step in the right direction, but highlighted that tariffs on Canadian steel, aluminum, timber, and autos remain and continue to inflict serious damage on Canadian workers. That was the proper read. The verdict is a legal win, but not an economic one. Not yet. The economic agony is still occurring under Section 232, but the legal framework of the larger tariff regime has broken, and Canada is now negotiating with that breakdown at its back. Earlier this week, LeBlanc sat down in Washington with U.S. Trade Representative Jameson Greer. It was the first in-person high-level trade meeting between Canada and the United States in months. The talks had been halted since October, reportedly because the Trump White House was outraged about a Canadian television advertising that paraphrased Ronald Reagan opposing tariffs. LeBlanc introduced Canada's new chief trade negotiator, Janice Charette, and incoming ambassador, Mark Wiseman. Greer and LeBlanc described the debate as constructive and substantive. They decided to communicate again in the coming days. Receipt number 1, the financial math. $165 billion in IEEPA tariffs were collected by the U.S. Treasury to January 2026. The Penn-Wharton budget model predicts overall refund exposure at $175 billion when penalties and interest are incorporated into continuing legal claims. That is not money Canada receives directly. It is money that U.S. importers, American firms, American manufacturers, and American merchants who paid the tariffs can now pursue through the U.S. Court of International Trade. But every dollar of refund claim diminishes the financial justification for the tariff regime and increases the political case that the entire IEEPA tariff plan was an expensive, illegal blunder. For comparison, the average American household absorbed an estimated $700 in higher prices from the 2026 tariff round. They will not forget that number when they vote. Receipt number 2, the Section 232 shield, the tariffs that remain, steel at 25%, aluminum at 10%, autos at 25%, cover nearly $35 billion in yearly Canadian exports to the United States, representing 1 full percent of Canada's GDP. This is not inconsequential. General Motors has already stated to investors that its 2026 outlook includes $3 to $4 billion in estimated tariff charges as a critical forward-looking risk. Canadian households are absorbing an estimated $1,700 to $2,000 in higher annual expenditures from the cumulative tariff impact. The Section 232 protection implies this misery remains even after the IEEPA apparatus collapses. Canada knows this. That is why LeBlanc's March 6th meeting was not a victory lap. It was the commencement of a new and harder negotiation. Receipt number 3, the market reaction. When the Supreme Court verdict came this morning, the Canadian dollar surged 0.88% against the US dollar inside the first 30 minutes of trading. The Toronto Stock Exchange's Materials Index, which monitors steel and aluminum companies, rose dramatically. In the United States, the S&P 500 materials sector lost 1.4% as traders recalibrated the legal endurance of the overall tariff architecture. Bond markets in both nations observed the shift. The universal read from institutional investors was clear: the legal foundation of American trade policy just crumbled and the crack runs deeper than the White House is admitting. Receipt number 4, the strategic psychology. For 14 months, the Trump White House operated on the notion that IEEPA granted the president basically unlimited ability to put economic pressure on any nation at any time for any declared emergency at whatever tariff level. That notion permitted the administration to threaten and escalate without restraint because the constraint, Congress, the courts, international bodies, appeared too sluggish to matter. The Supreme Court just proved that notion false in one ruling. And because it is a Supreme Court ruling and not a lower court injunction, there is no appeal. There is no procedural delay. There is no waiting for a stay. The authority is gone. The mindset of unbounded executive trade power, the dread that grounded every discussion the White House had with every trading partner, is irrevocably broken. Here is what happened in Washington when the ruling hit. The ruling was published this morning, and the U.S. Trade Representative was notified simultaneously with the White House. According to sources inside the administration, the instant read from legal staff was that the verdict was narrower than feared, that just IEEPA duties were hit, and that Section 232 survived. That initial read provided a brief window of false calm. Within the hour, that calm crumbled when staff learned the $165 billion refund exposure was not theoretical. Businesses had previously started filing protection claims in anticipation of just this outcome. Shortly after, the National Economic Council conducted an emergency session. The essential question was not whether the verdict could be appealed. It cannot. The essential question was what authority remained for the president to inflict tariff pressure before the legal replacement vehicle could be stood up. The answer was Section 232 and Section 301, both of which survive, and Section 122, which could be implemented as a global substitute, but carried its own legal difficulties. By mid-morning, the decision to activate Section 122 had been made. Then Trump was briefed. According to reports, Trump was upset in a specific and telling way. He was not outraged particularly over the judicial ruling. He was upset that 2 of the 6 justices who voted against him were his own selections. He allegedly asked aides to identify who had recommended those justices and whether they had known this would happen. He denounced the ruling as a disgrace and a betrayal. He used the word betrayal. When aides emphasized that the court cannot be persuaded to reconsider and that the majority includes justices across the ideological spectrum, Roberts, Sotomayor, Kagan, Gorsuch, Barrett, and Jackson, Trump reportedly went silent for over a minute. That quiet told everyone in the room everything about how seriously he comprehended what had just happened. Hours later, the White House made an official statement. Trump called the ruling deeply disappointing and said he was ashamed of the justices who sided against American workers and against the president's authority to protect the American economy from unfair trade. The statement announced that the administration would immediately pursue alternative legal authorities to maintain appropriate trade measures. Translation: they were already developing the Section 122 replacement before the statement was finalized. By early afternoon, congressional reaction broke in both directions simultaneously. Senator Chuck Schumer of New York branded it a total repudiation of the president's trade agenda and asked that Congress draft legislation to permanently restrict the executive branch from using emergency declarations as a tariff mechanism. Senator Marco Rubio defended Trump and suggested that the verdict indicates judicial intrusion into presidential foreign policy. But it was the Republican who broke the pattern. Senator Lisa Murkowski of Alaska, whose state sends large agricultural and energy exports through Canadian infrastructure, stated quietly and on record that the verdict represents the fundamental notion that even emergency authority has limits, and that limits are not weakness. They are the law. When a Republican senator tells the White House that the law extends to the president, the legal defeat is no longer partisan. It is institutional. By this evening, the Section 122 10% global surcharge was officially revealed. Markets closed, mixed. Legal challenges are already being prepared. Let me offer you 3 scenarios. Scenario 1, the coerced compliance. The 24-state action against Section 122 prevails in federal court within 60 days. The substitute tariff regime is enjoined while the litigation progresses. The White House, now shorn of both IEEPA and Section 122 authority, is left with just Section 232 and Section 301, both narrower, both slower to deploy. Canada and the United States approach customer review negotiations in the coming weeks, with the U.S. holding drastically decreased influence. Carney utilizes the legal vacuum to demand elimination of the remaining steel and aluminum tariffs as a condition of CUSMA renewal. The White House, facing an election cycle with no tariff revenue and refund commitments in the hundreds of billions, agrees to a partial reversal. CUSMA is renewed with changes. Canada wins most of what it asked for. Scenario 2, the protracted war. The Section 122 surcharge escapes initial judicial challenge on technical grounds. The CUSMA review deadline of July 1st arrives with both sides still discussing. The U.S. hints it may not extend CUSMA automatically, preferring to renegotiate bilateral arrangements with Canada and Mexico independently. Canada resists bilateral negotiations without Mexico. Mexico, empowered by its own parallel economic relationships, refuses to be divided from Canada. The trilateral framework holds together not because of trust, but because separating it would trigger the Section 122 exception for CUSMA items to expire, which would affect American businesses more than Canadian ones. Negotiations drag into the fall, markets pricing in 18 months of uncertainty. The cost is borne by workers in all 3 countries. Scenario 3, the permanent rupture. The Section 232 tariffs on steel, aluminum, cars, and lumber remain in force through 2026, regardless of every judicial challenge to IEPA and Section 122. Canada's GDP absorbs another 1.5% to 2% drop. Political pressure inside Canada increases the diversification of commerce away from the United States. Canadian exports to the European Union grow. Canadian energy accords with Asian markets close. CUSMA is ostensibly renewed on paper but hollowed down in practice as both Canada and Mexico root growing portions of their trade around the United States. The legal triumph at the Supreme Court becomes a symbolic landmark. The time the court acknowledged the law has limits, but the economic damage is already done and the relationship is forever transformed. I'm watching whether the 24-state lawsuit against Section 122 receives an emergency injunction in the next 30 days, whether any major North American automaker publicly announces a supply chain shift in response to the ongoing Section 232 auto tariffs, and whether the Canadian government formally files refund claims against IEPA tariff collections on behalf of Canadian exporters. Because if Ottawa swings from legal posturing to aggressive financial recovery, this story enters a phase that has no modern parallel. The Supreme Court killed Trump's tariffs. $175 billion in legal exposure now sits against the U.S. Treasury. And it was Trump's own appointees, the justices he handpicked, the judges he swore would preserve his agenda, who cast the votes that brought the entire architecture down. That is not irony. That is the law working exactly the way it was meant to work. 114 days left before the CUSMA review deadline, and the United States is bargaining without its most formidable weapon,